Hi, I'm Steve Barlow, Vice President and General Counsel for the Works Incorporated, and I'd like to welcome you to the Renters' Rights and Responsibilities Workshop. This workshop is made possible with funding from Shelby County Division of Community Services and in partnership between the Works Incorporated, West Tennessee Legal Services, Memphis Area Legal Services, and the Community Legal Center. It's important to talk about your rights and responsibilities as a tenant and to understand them. I believe we've put together an excellent program which can help you learn more about your rights and responsibilities, some of the common issues that are faced when renting a place to live, and some of the best practices for renters who are dealing with landlords and with difficult, sometimes living situations. You can learn more about code enforcement and learn more about what resources are available if you need legal help or if you need to reach code enforcement. So there's plenty of resources out there, and you'll learn more about those resources. The presenters today, first you'll hear a little more about the Works Incorporated from Rashawn Austin, who is the president and CEO of the Works Incorporated. After that, Judge Danielle Mitchell, who's a judge in the General Sessions Court, will talk about what the experience of a litigant in the General Sessions Court is like. After that, Nicole Greta, CEO of Memphis Area Legal Services, will be talking about the Housing Stability Program that is ongoing in the Shelby County General Sessions Courts. And then Vanessa Bullock, Deputy Director for West Tennessee Legal Services, will be giving an educational session about rights and responsibilities of a tenant. Finally, Roderick Nelson, Operations Manager for the City of Memphis Division of Community Enhancement, or Code Enforcement, will talk about how code enforcement works in this community and things you should know about code enforcement. I want to point out that this presentation is not legal advice. You should consult a lawyer if you have a legal question. And we're looking forward to getting your feedback about our presentation tonight. Now, with that, I'll hand it over to Rashawn Austin, who's going to give a little introduction to the Works Incorporated in Memphis, Tennessee.
Hi, I'm Rashawn Austin, President and CEO of The Works Incorporated. The Works Incorporated is a community development corporation working in the Memphis, Tennessee region. Initially founded in 1993 out of a faith ministry to address the social and health needs of the neighborhood surrounding the church. In 1998, our organization embarked on the development of affordable housing to meet the needs as defined by the residents in the surrounding area. At that time, we developed single-family homes for homeownership, and quickly we expanded into doing affordable housing for very low-income renters. And so we became landlords. We expanded our work to address the more comprehensive needs of our neighbors, addressing food, health and well-being, the built environment, and climate. Neighborhood stabilization is key to our work. So we must protect the most vulnerable populations, many of whom are our tenants, and they need to understand their rights and responsibilities in their housing. We're happy to be a part of this partnership with others to help tenants, very vulnerable populations, remain in their homes and stabilize neighborhoods, and thus we stabilize our entire community in the Memphis region.
Thank you, Rashawn. Next up, we have Judge Danielle Mitchell, who's the General Sessions Court Judge for Division 3.
Thank you, Steve. Hello, I am Judge Danielle Mitchell, and I serve you as a judge of Division 3 of Shelby County General Sessions Court here in Memphis. General Sessions civil courts handle matters that amount to less than $25,000 in property matters. Our courts handle many everyday legal matters that touch people's lives, like what we're here to discuss today, landlord-tenant disputes that may ultimately lead to the filing of an eviction. As a judge, I believe strongly that everyone who walks into the courtroom, whether they're a landlord, whether they're a tenant, whether they have a lawyer, or whether they don't, deserves to be treated with dignity, to understand what's happening in their cases, and to have a fair chance to be heard. That's especially true in eviction cases, where what's at stake is something as fundamental as having a roof over your head and a place to sleep at night. That is why I'm so proud to have partnered with the Community Service Agency of the Shelby County government to help facilitate resources for litigants on all sides of landlord-tenant issues. I'll talk a little more about that later. First, I want to talk to you about how eviction cases work. An eviction case usually starts when a landlord files what's called a detainer warrant with the General Sessions Civil Court Clerk's Office. Let's pause right there. People hear the word warrant and get a little afraid. This is not an arrest warrant, okay? A detainer warrant is just the lawsuit that lists the reason that the landlord is suing the tenant and wants possession back of the property. Most of the time, it's for issues of non-payment of rent, but there could be some other legal issues or other violations of the lease that they're talking about. Once that warrant is filed, again, an arrest warrant, no one's going to jail, the court clerk will set a court date and the warrant has to be served on a tenant. What that means generally is that a Shelby County Sheriff's officer or a process server will come hand you a piece of paper in your hand, letting you know when and where to appear at court. The warrant can also be what we call posted at your property address. That means when you come home one day and there's a notice taped to your door, you'll need to hold on to that notice. On the court date, when you come to court, both sides will come before the judge. At your first court case, the plaintiff, your landlord, will ask the court for some sort of relief, whether they want past due rent or they simply want you to vacate the property or what we call possession of the property. Many cases actually resolve that day. Sometimes the parties agree to a payment plan, they agree to a move-out date, or another arrangement that avoids a contested hearing. Now, if you don't like what your landlord is saying, you don't agree to any kind of arrangement, you have the right to have the case be continued or be reset for trial. Trials are usually rescheduled in 7 days based on Tennessee law. At trial, both parties, landlord and tenant, will have the opportunity to be heard. So make sure you bring all your evidence with you. You want to bring all the proof that you have, all the receipts, pictures, emails, text messages, anything you have to explain your side. You want to raise any defenses you may have, or if you try to work out an agreement with the landlord. Now, if the two parties can't agree, the judge will hear the evidence and make a ruling. If the two sides can't agree, the judge hears the evidence and makes a ruling. If the judgment is in favor of the landlord, the tenant generally has a period of 10 calendar days before they have to move from the property. I want to be clear, though, because I want you to understand that while being served on an eviction warrant is serious, it is not the same thing as being evicted that day. There is a legal process that the landlord has to go through, and you have the right to participate in it. Okay? If you are served on an eviction warrant, the first thing I want you to do is zoning board. Okay? It can be tempting to throw it away and just not worry about it. But if you don't come to court on your court date, the court may and likely will enter what's called a default judgment. That means there will be a judgment taken against you by default because you did not show up to defend against your case. So you've also lost the opportunity to tell your side of the story. Secondly, I want you to make sure you read the detainer warrant carefully. It will tell you the date and time of your court case, as well as the reason why your landlord is seeking possession of the property. Third, gather your documentation. That's the proof we were talking about. Bring everything you feel you need to prove and defend your case. Bring it with you every time you come to court. Fourth, and I cannot stress this enough, consider seeking legal help. You are not entitled to an attorney in civil court, but it is important that you get advice from someone who understands the law and the legal process. I mentioned earlier I was a part of a partnership with the county to provide resources for people. The Community Resource Room is located in room 134 of the Shelby County Courthouse. That's right next to my courtroom. The advocates that work there are a wealth of information about services and resources that can help you. They do a fantastic job helping the public, and I could not be more proud of the work they do. There are also local legal aid organizations here in Memphis and Shelby County. You'll hear more about them later, like the Memphis Area Legal Services and West Tennessee Legal Services. They provide free or low-cost assistance to tenants facing eviction, and I'd encourage anyone in this situation to reach out to them well before their court date, if all possible. So now I want to talk about the practical side, because I understand facing an eviction is a stressful thing. First things first, you will want to come dressed appropriately to court. Professional attire is required. That means no shorts, clothes with offensive writing, strapless or halter tops, etc. If you bring your cell phone in the court and it alerts, just know it'll likely be confiscated. Each judge has their own policy as it relates to that, so make sure that you silence all devices. Because I also know that navigating a courthouse can be intimidating, know that the General Sessions Civil Court is located at 140 Adams Avenue in the historic Shelby County Courthouse in downtown Memphis. That's the same general area as other county buildings, including City Hall and 201 Popper. So get there early. There is parking nearby, but it is not a quick process to get in the courthouse. You want to make sure that there is enough time for you to find your courtroom and get there before court begins. When you get to 140 Adams, you'll go through security at one of the 3 entrances to the building. Now, you can't bring certain things into the courthouse. It's kind of like when you go to the airport. So please leave any prohibited items that you have at home or in your car. Know that all General Sessions civil courtrooms are located on the first floor of the courthouse. There is electronic signage in the southwest corner of the building where you can find what court division you're supposed to be in. If you can't find that, or if you can't navigate it easily, always feel free to go to room 106 of the General Sessions Court Clerk's office to ask what court division you're supposed to be in. If you're ever unsure of where to go, do not hesitate to ask. The court clerks and the sheriff's deputies are there to help, and no question is a bad question when it comes to finding your courtroom. Take a break. And is the pace okay? Is that yeah? Okay. Again, I strongly encourage that you arrive early. Give yourself time to check in, to find your courtroom, and settle in before your case is called. Cases are often called in the order they appear on the docket, so there may be some waiting involved, and that's completely normal. When your case is called, you and the other party will come before the judge. We'll ask both sides to state their names, and then we'll go through the case. If you have a defense, this is your moment to explain it. If you and the landlord have reached an agreement, you can announce that to the judge as well. I want to be clear about something. You don't need an attorney to appear in General Sessions Court, though having one or having assistance from legal aid is highly advised, especially if your case is complicated. The judges in our building want to make sure that everyone, represented or not, has a fair opportunity to be heard. One last quick point I want to mention. If you are a tenant and have filed for bankruptcy, please let the judge know immediately when your case is called and have your docket number ready. That is important. In closing, I want you to know that eviction cases are some of the most consequential matters that come through our courts. Judges don't take that lightly because they affect something as basic as housing. My hope in speaking here today is that if you ever find yourself served with an eviction warrant, you'll feel a little less afraid and a little more prepared, that you'll know where to go, what to expect, and you'll know that you have a voice in the courtroom. Thank you.
Thank you so much, Judge Mitchell. Next up, we have Nicole Britta, CEO of Memphis Area Legal Services. Thanks for being here, Nicole.
Thank you, Steve. I appreciate being a part of this partnership, and I'm here to talk to you about a grant that we have from the Shelby County Commission. It is the Housing Stability Solutions Program, and it is a program by which we can assist tenants living in Shelby County who have habitability issues. That's just a fancy way of saying we can help people who have landlords who don't fix things they should. This is designed to be an alternative to the voluminous number of evictions that we see each and every day being filed at Shelby County General Sessions Court. And thanks to Judge Deborah Henderson, we were able to secure this funding from Shelby County. Our ultimate goal is to break the cycle of landlords renting residential properties to tenants with deplorable conditions, evicting those tenants or failing to pay their rent. Who wouldn't want to stop paying their rent if their landlord wasn't fixing things in their home? As my colleague will tell you here in a few minutes, don't ever do that. We cannot withhold your right in Tennessee, even when your landlord's not doing what they're supposed to do. But with this program, we can get in before that happens. You have an issue, your landlord's not fixing things, you can contact our office, we can do an intake with you, and we can see if we can get one of our code inspectors out there to inspect the property, see what's wrong, see what needs to be addressed. They can prepare a report, and then we can send that report to your landlord, making a demand, as lawyers in my office often do, that they do what they're supposed to do on your block. Long term, we hope that this program will also allow us to work with the environmental court. I'm sure many of you have seen on the news where large complexes and other complexes, small properties all over the county are being taken to environmental court because they're not addressing code issues. So ultimately, our goal, like I said, is to break that cycle. And we're very thankful to the Works for this partnership, to Shelby County for the funding to do it. And with that, I'd like to turn it over to my colleague, Vanessa Bullock, who is the Deputy Director at West Tennessee Legal Services.
West Tennessee Legal Services is happy to be part of this partnership and hopes the implementation that we provide today will assist tenants in making new decisions that help them enjoy their homes and reach stability in their households. To begin with, we're going to start with some rights and responsibilities. West Tennessee Legal Services is happy to be part of this partnership in hopes that the information we provide today will help individuals reach housing stability and enjoy the use and enjoyment of their homes. We're going to start today with some rights and responsibilities, and we're going to talk about tenants' rights, the landlord's responsibilities, some common issues that we see, and how we can fight retaliation and fight evictions if that's something you are experiencing. And we're going to end today's session by going over some best practices for tenants to help you select the right unit and protect yourself while you're living in that unit. So, what are the most basic tenants' rights that every individual should have? The first right is the right to use and enjoy your rented premises. So you should be able to be in your household, have full use of it, and be able to do so without having a neighbor or a landlord or some other individual come in and stop that use or prevent you from accessing services that you're entitled to. Have housing free of discrimination because of your race, color, religion, national origin, sex, familial status, meaning is there a child under the age of 18 in the household, or your disability status. Basic landlord responsibilities. First of all, they have to keep the apartment habitable and make repairs. They must also comply with local building codes. And then second, they must not discriminate against anybody or harass the tenants. They also must make reasonable accommodations for tenants with disabilities. Reasonable accommodations are changes to the rental terms that help an individual with disabilities have the full use and enjoyment of the property. Some common examples might be allowing an assistive animal. When a person has a disability, we need that animal to provide a service for them. It may also include things like allowing a tenant to have a designated parking space because they had a mobility impairment that makes it difficult for them to walk from the parking lot to their unit. And there are many other examples. And if you believe you've experienced housing discrimination, please contact one of our offices for assistance. Next, we're going to talk about repairs. Repairs are probably the largest problem that we see in our service area. And as Nicole said, they have a full program that is targeting non-repairs in situations that tenants are being put into due to the failure to make repairs. And these repairs can be everything from major structural damage, things like having a hole in your floor, having a hole in your roof, having the ceiling fall in on you, broken stairs, walls that had giant holes in them, to things like having no heat or air conditioning, having electrical problems in your household, having plumbing issues or lack of running water, pest infestations, roaches, bugs, mice, also things such as leaks and mold, windows issues, and the list could go on and on and on. With an NGO property supply and a tight rental market, many landlords are finding that they can rent properties without making the repairs because the demand is so high and the supply is so low. And so once you're into that situation, what are your responsibilities as the tenant? First, when do you have to make those repairs or cover the cost for the repairs? If you or someone in your household or your guest calls a repair problem, you're going to have to pay for those repairs. And this includes things that your children or children that come with your guests may do. So we had situations where children threw things down the toilet that caused plumbing issues. And that does become the tenant's responsibility at that point. Also, it may be your responsibility to pay for certain repairs if you signed a lease that says you are responsible for those repairs. So it's very important that you read your lease terms, you keep a copy of that lease, and you talk with an attorney if you do not understand one of the terms in your agreement. Otherwise, making and paying for repairs to keep the apartment habitable and maintained is the landlord's responsibility. So, what can you do if you need repairs in your unit? There are a few steps that you can follow. Step 1, you have to tell your landlord in writing that you actually need these repairs. Be specific about what's going on and give the landlord 14 days to make those repairs in those cases. If it's an emergency repair, such as lack of water or lack of heat, you may be able to give them a shorter period of time. Keep a copy of the request for your records, because if you get into a dispute with your landlord, it has to go to court. It's all going to be about what you can prove you told the landlord. And having the request in writing and having a copy of it is very important. It has to allow your landlord reasonable access into your home to make repairs. So if you ask for repairs, you have to let them in to make that repair. Reasonable access means generally within normal business hours of 8 a.m. to 5 p.m. And you need to arrange alternative hours with your landlord. That may be permissible as well. But you shouldn't expect your landlord to send someone after midnight or 5:30 in the morning, things like that. Next, if that doesn't work, what can you do? There's an optional step to all code enforcement, and there's going to be a session on code enforcement at the end of this, so I'm going to let Mr. Nelson tell you about that process, but that is an optional step that you can take. Then, what if they still have not in those repairs? At that point, you have a choice. You can break your lease entirely, or you can sue your landlord in court. If you get to steps 3 and 4, I highly suggest you have an attorney. Our laws are very particular in what you must do to protect yourself, and it's very important to do that with the advice with the assistance of a lawyer if you can find one. The agencies providing the presentation today provide free legal services for low to moderate income households, so please feel free to contact our agencies for possible assistance. Now, what if you are a person with disabilities and you need repairs? You may have some additional rights if the conditions are making the symptoms of your disability worse. In that case, you can ask for the repairs as a reasonable accommodation under the Fair Housing Act. And this is important because it allows you to make the request under a federal law rather than our state landlord tenant laws. And once you get under that federal law, you have additional protections, additional rights, and additional leverage to help you in your case against your landlord should it go to that. So, big 3 on repairs. First, put all notices to the landlord in writing. Document everything and take photos. And store them in a place where you can access them later. Sometimes cases can take many months or even years. And so if you have them in a phone or online and you no longer have access to them, those photos are not going to help you. Second, and this is probably the most important, do not stop paying your rent. Tennessee does not allow you to stop paying your rent for non-repairs. You're going to see a lot of information online that tells you otherwise, and that is incorrect. Getting real advice from TikTok, Facebook, your aunt that lives in California or Mississippi, it's not the best place to get advice. I'm telling you, Tennessee law says you cannot stop paying your rent, and that is very, very important. Once you stop paying your rent, you're going to have a much harder time taking any action against your landlord. And 3, always read your lease and keep a copy of that lease. The rules can change depending on what your lease says, and that is a very important document to have and to understand. So, after repairs, the next issue that we see come into our office most is termination of tenancy. So someone has been told they have to leave the property or they're going to be evicted and taken to court. What does that look like and what process should that follow in the state of Tennessee? So there are a couple of different ways and a couple of different processes that may play into your situation. There are different types of rentals, and which process should be followed will depend on where you're living. If you are living in property that is income-based, such as at the Memphis Housing Authority, or under a Section 8 voucher, or in a project-based unit, you have some additional rights that make it harder to evict you. How strong that protection is will depend on what exact type of housing you are living in. And so it's really important that you understand what type of income-based rental you're in. And if you don't, to seek the advice of an attorney who understands the different properties and what their different rules are. But all income-based properties have a general good cause eviction requirement. So housing providers in that situation just can't tell you to leave because they want you to leave. They have to have a reason. And the good cause helps to stop retaliation and discrimination by requiring the landlord to show that good cause to evict or to non-renew your lease at the end of the lease term. If you are living in one of these properties, if you pay the rent and follow your lease, you should get to stay there as long as you qualify for that housing. Some common examples of what would be considered good cause to evict situation are non-payment of rent. You have to pay your rent. Violating the lease terms. So again, very important to read your lease and understand what you're agreeing to do. It's also the cause if you continually cause a nuisance or a violation of the law. And if you fail to recertify or sign your lease renewal. Or if you refuse to provide access to the apartment. These are all things that, if they happen, could be enough to establish what calls for eviction or non-renewal. So if you ever get into that situation, again, our offices are here to help. Please reach out. Now, what if we don't live in an income-based property? What does the process look like for you? Again, it's going to depend a little bit on everybody's situation. So there are two types of private tenancies that we see in the state of Tennessee. The first one is what we call a fixed term tenancy. So this is where you have a lease agreement for a set term. Generally 12 months, but sometimes they're a little bit shorter. Sometimes they may be a little bit longer. If you're in a lease agreement and you follow all the rules outlined in the lease, you should not be terminated during the terms of that lease agreement. So you should get to live there for as long as the lease runs. Again, generally 12 months. Now, what if you get to the end of that period? What happens then? The landlord can either renew your lease or they can decide to tell you they want you to give up the property. And unlike in income-based properties, private landlords do not have to have good calls not to renew. So they can just decide they want to get all the tenants out so we do renovations. They can decide that they just want you to get out because they no longer like reading to you. And it's going to be really hard to challenge that anymore. Now, one thing to say is they cannot decide not to renew you because of your race, color, religion, sex, national origin, familial status, or disability status. That discrimination stuff that we talked about earlier. But again, as the person claiming that's why they're not winning you, it's going to be on you to prove that. And that's going to be difficult to do. The next type of tenancy you may have is a periodic tenancy. So this is a situation where you don't have a lease, or maybe you had a lease that has ended and you hadn't signed that lease. And in this situation, you are a periodic tenant and can have your lease non-renewed at the end of any rental period. Generally, what we see are month-to-month tenants, where a tenant pays rent every 30 days, and in that case, they'll be entitled to 30 days before they're not renewed. But there are also situations where people may pay their rent bi-weekly or even daily or weekly. And in those situations, they're going to be entitled to a shorter period of notice. So for daily or weekly rentals, you are entitled to a 10-day notice. And one thing about these daily rentals, this can include living in a hotel or motel once you have been there for 30 consecutive days. We see a lot of situations where people will live long-term in a hotel or motel, and at some point, the hotel or motel will get upset with them and just cut off access to the property. That's okay, days 1 through 29. But once you get to day 30, you are now a tenant of that property, and they have to follow the same eviction proceedings as any other landlord. Next, if you are a bi-weekly tenant, you are entitled to a 14-day grace before they can terminate your tenancy. This means they need to tell you, or put in your writing, that we want you out in 14 days. And then, like we talked about earlier, monthly, you're entitled to 30 days. So what happens if he don't leave once that termination notice has expired? At that point, the landlord must kick you to court to have you removed by the sheriff. They cannot just jump up and remove you themselves. They have to take you to court. The judge has to order that you are to be removed. And then after 10 days, they can ask the sheriff to come and set your stuff out. Now, there are some additional protections that may come up in your rental situation dealing with retaliation. All landlords are prohibited from retaliating against tenants for asserting their rights under the law by doing things like increasing the rent, decreasing the services, or by threatening or bringing eviction. Landlords also cannot harass tenants by using their right to access the property. If these things are going on, that may be a defense to an eviction action that the landlord brings. But if you are going to make a defense in court, it's going to be up to you to prove that these things were happening. So again, documentation, keeping records are very, very important. Also, at this point, if you suspect that retaliation is happening, again, I strongly encourage you to reach out to one of our agencies to see if we can assist you, because it can be very, very important to keep the documentation in a way courts will accept. So, your landlord cannot lock you out without taking you to court first. They cannot shut off your utilities, remove your doors, or break your locks. And they cannot otherwise harass you or try to force you to move out. If they do, that's probably an illegal eviction, and you'll have a good defense support should they try to come after you for damages, and you may even have the ability to sue the landlord for what they've done. So, we talked about rights and responsibilities. We've talked about some of the largest issues that are coming into our office every day. Now we're going to talk about some best practices that will hopefully help you locate and secure housing where these things are not issues. The rental starts at the beginning, when you select that unit. Never summer we spray unit without viewing that unit first, or at the minimum, touring the complex and seeing a modeled unit if it's available. We see so many situations where people rented an apartment based on just photographs that the landlord posted online, or an email the landlord sent. In that situation, you don't know if the landlord has put a rug over a hole in the floor, or when those photos were taken, or if they've been edited. It's very important to see the place with your own eyes and make sure it's up to your standards. Second, review the lease terms before you sign the lease or pay any deposit. And note in the lease that the deposit is listed as non-refundable. 3, take pictures of the unit as it is when you move it. And make sure you don't lose those pictures if you change phones or other electronics. Those photos may be the thing that saves you down the road. And finally, get any promises for repairs or other work in writing and signed by the manager. Don't just move in because they verbally tell you, oh, we'll take care of that, we'll fix that, no problem. If they're not willing to put it in writing, that is a big red flag. And you should listen to those red flags and look for them and keep them in mind when you're selecting a unit. Next thing, get renter's insurance. It's highly, highly advisable, and it's usually very affordable. One thing that we see coming year after year are tenants coming in because something has happened to the belongings while in the unit. In those situations, if it's a thing where there's a flood and where the ceiling caves in, generally the landlord or the homeowner's insurance is not going to pay to replace your belongings. They're going to pay to fix the property, but not to replace your belongings. That's what your renter's insurance is for and why you need to have it. In some situations, renter's insurance will even pay for hotel and motel costs if you're displaced due to an issue with your rental. So again, it's really highly advisable to have and to understand what you are buying or getting a renter's insurance so you can pick the plan that best meets your needs. One thing that we're seeing come up quite a bit lately are complexes that are including renter's insurance with the lease agreement. This insurance can be sufficient for you, but you need to obtain a copy of the policy, review it to make sure it actually meets your needs and it actually is going to cover the items you think it will cover. We've seen situations where it's been really good earnings insurance and it's helped our tenants. But we've also seen situations where it doesn't cover the property, it doesn't cover hotel motel costs, and there are big exclusions that the tenants have to face if they need to use it. Next, this is probably the biggest area of calls that we get yearly where, unfortunately, because the tenant did take the right steps at the beginning, there's just not a lot that we can do. Security deposits are an issue for people time and time again. And our local state law does cover security deposits in great detail and has a whole list of things you must do to get your security deposits back. But we're just going to go over kind of the big picture of security deposits in Tennessee today. So deposits can be used to cover unpaid rent or other damages that you leave when you vacate a unit. So typically you're not going to be entitled to the deposit back until you leave, and it's going to have things deducted for if you cause damages to the unit or get paid your last month's rent. So how do you protect yourself to make sure you get as much deposit back as possible? When you vacate the unit, you should take pictures of the unit as you leave it, with all the items removed and the unit cleaned. And again, it's very important to keep those pictures somewhere safe. And to the extent that you can make sure the pictures are dated and time-stamped, that's even more helpful. Also, you should do a walkthrough with your manager to review any damages together. If they claim some damages that you disagree with, you need to write what you disagree with and sign and date your name on that list. So say you'll walk around, they clean out a broken window, you agree you broke that window. Then you go into the kitchen and they point out a broken cabinet, and you know that cabinet's been broken since you moved in, and you disagree with that. You need to write on that paper where they note broken window and broken cabinet. I disagree with the broken cabinet. That cabinet was broken when I moved in. It's never been fixed. That will protect you if you need to move forward with suing your landlord or if your landlord tries to sue you for negligence. Finally, you have to leave a mailing address where they can forward the deposit after you move. If you don't tell them where you're going or tell them where they can reach you, they're not going to know where to send that deposit back. And our law does allow them to keep it after a certain period of time. They don't know where you walk. And then, if you do not receive the refund of your deposit, you can sue your landlord in general sessions. That is an option. Again, before you proceed to that, I strongly advise you seek legal advice from an attorney or one of our agencies. It's very difficult to sue in general sessions. There's a lot of specifics in trying to find a landlord, trying to get them served, that will be better handled by an attorney. So that concludes my presentation today, and I'm going to turn it over to the City of Memphis Code Enforcement, Mr. Roderick Nelson.
Thanks, Vanessa. So let's talk about the goal and objective of code enforcement. It's real simple. Our goal is compliance. We want all properties to be in compliance with the code ordinance. Our objective is to educate, engage, enforce to eradicate what? We educate residents by helping them understand housing standards. We engage, we work with both tenants and owners on violations. We enforce, he apply ordinances fairly to maintain housing funds. So what does the city of Memphis look like? The city of Memphis is currently 320 square miles. If I was to ask you how many code inspectors we have, you may say 200. Some of you may even say 10, but I'll tell you, we only have 55. 7 council districts, geographically, 7 council districts. We have 28 sub-districts. And what that means is we have at least one code inspector assigned to each one of the sub-districts. So at a very bare minimum, you have 28 code inspectors out fighting. But what that means in the terms of numbers, you have one inspector that's servicing over 16,000 citizens. So very good there. So what does code enforcement really do? This question is often tossed around. Most people don't know what code enforcement actually does. You'll learn today. We maintain a housing stock. We enforce the city of Memphis codes of ordinances. We ensure all properties meet the minimum housing standards. What is minimum? You walk into a room, you turn on the switch to cut on the light. The switch is supposed to cut on the light. That's what you call a minimum. If the switch doesn't cut on the light, then it's not functioning as intended. That's what we did with the borough members. We don't deal with specifics by county code. Oh, and you promote public health, safety, and welfare. We operate with efficiency and effectiveness. This is important because we got 55 code enforcement inspectors for the entire city of Memphis. So efficiency is paramount. And we hold both owners and tenants accountable. Then these return loafing. When it comes to the responsibilities of owners versus tenants, owners are responsible for repairs and maintenance. Also, tenants must follow their lease terms and report issues promptly. For the most part, tenants are responsible for the exterior property areas and the upkeep of the property that they are occupying. So it's important to know the difference. Understand your means. Read your lease carefully. Sometimes the leaseman place the responsibility for the repairs on you as a tenant. So it's important to read your lease carefully. And if you have questions about it, get in contact with one of the legal services mentioned. Others may also penalize you for code violations. So you can't park your car on the grass, right? It's a code violation. It can put you in violation of the lease. And for something as simple as that, your owner may want to, your landlord may want to evict you because you're in violation of their lease. High grass and weeds. You got to have the grass cut and maintain the low 12 inches. And it's a dollars that can go to you and to the owner. Most of the time it will go to you, but if it goes to the owner of this, and they are notified of this violation, they can put you in violation of the lease. So it's important that you to follow the code that you're supposed to be following. And know your responsibilities in your rights. It's important that you know that you're a team, but guess what? You have rights. And that's one of the things that I loved about this program. Most importantly, it helps you to enforce your rights. When there's a problem, what should you do? First and foremost, contact your landlord. That's the first thing you should do. And the reason being, they need to be able to be held accountable, mitigating any violation that's there. But they can't mitigate what they done though. It's important you don't use code enforcement as your maintenance hotline, or not the maintenance hotline. We hold them accountable for what they're supposed to do that you contacted them on and they failed to do. Also give reasonable time for repairs. So if it's a hole in the wall and you calling today, don't expect for it to be fixed tomorrow. Give a reasonable time. Call code enforcement if it's something unresolved. I'm going to backtrack a little bit. Emergency cases are different. And let me explain to you what those are. Those are raw sewage overflow, toilet overflowing in the house, in tub, etc. No air conditioning, no heat, and no hot water. We consider all of those emergencies. So in those cases, yes, do call. And then call your landlord. As it was said previously, do not withhold your rent. Saying they didn't make the repair, so you're going to withhold the rent. A lease is typically you're occupying the space in exchange for a certain amount of money for a certain amount of time. So if you're occupying that space, whether they made the repair or in a time frame, or they didn't do it, you're still occupying the space, which is part of what that lease describes. So please do not withhold your rent. And when you do get to court, you want the judge to be able to, for lack of better words, get the violate, right? Do not block access. Do not block access for reasonable repairs. This can put you in violation when you're interfering with code enforcement. You can be cited in court as well because you can block access for reasonable repairs, and it must be at a reasonable time. Definitely not 12 at midnight or when you're not home. So remember, do not rely on promises. This is very important. A lot of times when you're moving into a new place, you get promises from the landlord, you fixing them, painted. And if you move in and sign the lease without it being done, chances are it's not going to be done. And then you'll call us 3 years later. And then done it in 3 years. We'd be like, why didn't you call us the first time? So we could have addressed it beforehand. And a lot of times with people changing dwellings, we often see people in emergency situations. Although you may be in an emergency situation, still try to take your time because people will take advantage of you in your emergency situation and don't stuff you in a house or in an apartment that's not up to code because you need to move very quick. So it's important to take your time when you're transitioning from one property to another because you find yourself stuck in property that doesn't meet code requirements. And don't wait. Don't wait until things get out of hand. Call immediately so that the process can get started. You don't want to wait until 2 years later and say, hey, I haven't had air conditioning in 2 years. Should have called 2 years ago so that we could have gotten it fixed for you or at least taken the owner to court to hold them accountable. So it's important you don't wait until things get out of hand. Final tips. Code enforcement inspectors are not legal advisors. So please do not ask them any legal advice, but they are not attorneys. Keep your landlord's contact information current. This is very important because if there's a violation, compliance starts with notification to the responsible party. So you want to make sure you have accurate, up-to-date contact information. This is important. A lot of times people are paying the rent through Zelle, they're paying it through the cash out. We don't know any type of address that's on the owner. And it's important that you do because we need the information so that we can get compliance started relatively quick. And take evictions serious. It's important. Take it serious. Even if your landlord is not properly following the law and say they're going to put you out tomorrow, or take it serious. Although they can't do it like that, take it serious, contact your attorney because you don't want to show up after you get off work, you didn't take it serious, and all the stuff that's on the porch or in the yard, which is another code violation. We're not going to talk about that. However, it could rain. You didn't take it serious. So it is important that you take it serious and you contact legal services immediately, especially when you know they're not doing things by the law. They can't come in and just say, it's my brother will come to put you out. That's not how it works. It's a legal process. So please take it seriously. And understand, once you sign the lease, you control access to this house. I know a lot of times in apartments, people say the renters man or the front office has a key, but you control the access. They cannot come into your unit and you're locked in. You're supposed to come in there when you're there. Same thing with us. We're not coming in your unit and you're not there. So keep that in mind. It's a very important issue, and your rights are then violated when they come in and you're not there. So it's important you understand that you control access to your unit. If you have any code issues, feel free to contact City of Memphis Code Enforcement Department. You're going to do that by calling 311 or 901-636-7464, or you can call our Hollywood location 636-4750. On the educational note, go to www.memphistn.gov/black so you can learn more about blacks. Thank you for your time. I'm now going to turn it over to Steve.
Thank you, Mr. Nelson. Really appreciate code enforcement being here to give that important perspective. I want to make sure that the listener today has the opportunity to know who to reach out to for free and low-cost legal help. And so we're providing information on the screen right now about West Tennessee Legal Services, their website and their phone number, Memphis Area Legal Services, their website and phone number, and the Community Legal Center. Please make use of these very valuable, very capable resources in our community. And in closing, I just want to say thank you to our sponsor, the Shelby County Division of Community Services, and to our partners, West Tennessee Legal Services, the Community Legal Center, and Memphis Area Legal Services. And we at The Works are so proud to be a part of this community partnership trying to bring education to people who need it to improve the quality of life and the quality of habitability in our community. Thank you very much.